Hello, my name is Jesse Franklin-Murdock, and I'm a lawyer at Dhillon Law Group. Today I'm going to be breaking down the case Bonta v. Chino Valley Unified School District. Across California and in many states, parents are beginning to realize something troubling. In classrooms meant to nurture and teach, young children, sometimes as young as 9 or 10, or even younger, are being quietly guided by teachers and counselors down a path toward transgender identification and the lifelong medicalization that comes with it. These are not isolated cases. We've heard story after story of students, especially young girls, who feel discomfort with their changing bodies or are struggling emotionally. Instead of compassion and counseling, they're told they might have been born in the wrong body. And all too often, parents are never told and are even kept deliberately in the dark. This is not just about pronouns or social expression. After a child is encouraged to socially transition, it often becomes the first step in a medical pathway: puberty blockers, cross-sex hormones, and eventually, surgery. That's not exploration, that's lifelong medicalization. In 2023, the Chino Valley Unified School District in Southern California decided that enough was enough. The school board passed a policy that simply required schools to notify parents if their child asked to be treated as the opposite gender or requested changes to official school records. It wasn't, as critics claim, an outing policy. It was a parental notification policy. Teachers would simply be required to inform parents when the school is being asked to participate in a child's gender transition. We promptly intervened on behalf of 6 Chino Valley parents, mothers and fathers, who wanted to know what was going on in their children's lives. The state tried very hard to keep these parents out of the case, but we fought their efforts and won the motion to intervene. Our legal theory was grounded in the doctrine of substantive due process, the idea that certain rights are so fundamental that the government cannot infringe upon them, even if they are not directly spelled out in the Constitution. For over a century, courts have recognized a parent's right to direct their child's upbringing, including making medical decisions. When the state's own expert admitted that social transitioning is a treatment for gender dysphoria, it confirmed what we were arguing all along. Schools were administering psychological treatment without parental consent or even notification. By filing this lawsuit, the state was trying to prevent a school district from simply providing parents with notification. That's not just wrong, it's unconstitutional.
All right, the Chino Valley Unified School District says it is not deterred after a judge blocked its policy on transgender students. It requires the district to tell parents if their child identifies as transgender.
While the Attorney General won a partial preliminary injunction against Chino Valley's original policy, the district and parents prevailed in the big picture. The court upheld the requirement that parents be notified of changes to their child's records, and Chino Valley ultimately adopted a revised policy that ensured transparency without referencing gender. The state chose not to challenge it, and the state did not appeal the judge's ruling that the portion of the policy relating to record changes was constitutional. The message is clear. When it comes to raising and protecting children, parents must never be kept in the dark. We at Dhillon Law Group will always fight for parents' rights to be involved in their children's most important decisions. This is Anatomy of a Lawsuit. I'm Jesse Franklin-Murdock. Thanks for watching.